Still says we're in practice session. All right, good morning, everybody. This is Chair Michelle Espinoza, and I'm calling the Real Estate Committee meeting to order today on August 1st, 2023. Marcia, may we get roll call?
Michelle Espinoza.
Here.
Graham Kaltenbach.
Here.
Joe Chang.
Here.
Renee Lind.
Here.
Josh Bradbeck.
Present.
You have a quorum.
Thank you. May I get approval of the June 6, 2023 Real Estate Commission meeting minutes?
I motion to approve the June 6th meeting minutes.
Thank you. Do we have- Thank you. Any further discussion? Hearing none, I need a roll call, please. Or all in favor. I apologize.
Aye.
Aye.
And Josh, I believe you'll be abstaining, being that you weren't here.
Correct, yes.
Great. Motion passes as presented. I need approval of the June 20th, 2023 Real Estate Commission non-rulemaking hearing minutes.
I motion to approve the June 20th non-rule making hearing minutes.
Second.
Thank you. We have any discussion? All those in favor?
Aye.
Aye.
Abstain.
Thank you. Motion passes as presented. Do we have any public presentation of issues not on today's meeting agenda?
If anybody from the public would like to address the commission, just please hit the hand icon. We'll call your name and unmute you. And Madam Chair, I do not see anybody that wishes to speak.
All right. Do we have any agenda items for our next meeting? Is there anything anybody wants to see or needs to discuss? Hearing none. I guess we have nothing. All right. Moving on to, we have hearing matters this morning. So we will now take up hearing matter, excuse me, cases RC 2020-0037 and RC 2020-0036, Colorado Real Estate Commission versus Donald Corum and Laura Corum, and the remand from the Colorado Court of Appeals to determine an award of reasonable attorney fees. Present to assist the commission in reaching a decision here are Deputy Director Eric Turner, Senior Advisor Melissa Phipps, Adjudicatory Counsel Natalie Powell, and I believe we had somebody else join us, Lisa Nichols.
Chair Lisa Michaels.
Lisa Michaels, I apologize.
Yes, thank you.
The commission today addresses the remand order from the Court of Appeals, which requires the commission to determine the amount of reasonable attorney fees to be awarded jointly and severally against respondents, Donald Corum and Laura Corum, and their attorney of record, Lindsay Ressler. Oral argument has been requested by both parties. Should the commission grant oral argument, each party will have 10 minutes to present oral argument. Before we get to oral arguments, I will invite a motion for the commission to enter executive session to confer with our adjudicatory counsel. Do I have a motion to convene an executive session to confer with our adjudicatory counsel under Colorado Revised Statute 24-6-4023A2 regarding the Court of Appeals opinion in the matter of commission versus Donald Corum and Laura Corum, case numbers RC 2020-0036 and 2020-0037, and seek legal advice on specific legal questions in order to reach a determination on a reasonable attorney's fees award. As part of the motion, I do invite those previously discussed as present, along with support specialist Doreen Archuleta to join executive session.
Madam Chair, I move that we move into executive session.
Thank you so much. Do I have a second?
Second.
Thank you so much. All those in favor?
Aye.
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 Any opposed? Motion passes. We will now convene an executive session by joining the separate executive session link. Please make sure you mute your volume and stop your video before you enter over into the other executive session link.
I don't have.
I do not think we have everybody here yet, so we'll wait just another until everybody joins. I believe we're still missing a commissioner. There we go. All right. We are resuming the public session discussion in our scheduled hearing matter. Before engaging a deliberation, the commission will first address both parties' requests for oral arguments. By commission rule, it is within sole discretion of the commission to grant or deny a request for oral argument. May I have a motion to grant or deny the party's request for oral argument?
Sure, Madam Chair, I move that we grant the request for oral argument.
Thank you. Do we have a second?
Second.
Thank you. All those in favor?
Aye.
Aye. All right. We are ready for oral arguments.
And Madam Chair, is there a particular order you would like to listen the petitioner or respondent to go first?
I would like petitioner, please, to go first.
I think petitioner's counsel may be muted. Can someone unmute her, please?
Yes. Oh, okay. Oh, you know. Okay.
Gina Canan is counsel for the petitioner in this case.
Okay, one moment. All right, Ms. Kanan, you should be able to put your camera on and unmute yourself. And I will be the timekeeper, and I'll let everybody know when 10 minutes is up.
Thank you.
Good morning, commissioners.
Good morning.
Sorry, I'm trying to adjust my screen now that it's in a different view. You have in your packets extensive documentation supporting the petitioner's request for attorney's fees. That request is now $39,240. The petitioner concedes that there was a mistake in Senior AAG Devin Leho's time entry on March 2nd, 2022. So we're subtracting 1.5 hours of his time for a total of $39,240. I just want to touch on a couple things. One is, I want to be clear, the Court of Appeals already awarded attorney's fees. That's already been decided. This case was remanded only for determination of the amount of the commission's reasonable attorney's fees. When courts calculate what reasonable attorney's fees are, they calculate the lodestar amount. That's essentially the amount of hours reasonably expended on the case multiplied by a reasonable rate. And the quorums have conceded the rate requested is reasonable on page 4, paragraph 11 of their response. So the only issue remaining is whether the amount of hours was reasonable. Excuse me. Under prevailing case law, courts look to the Rule of Professional Conduct 1.5 for the factors that make a fee reasonable, many of which are applicable here. They include the time and labor required, the skills requisite to perform the legal service properly, the results obtained, the fee customarily charged in the locality for similar legal services, and the experience and ability of the lawyers performing those services. So in light of those factors, I want to address a couple of the quorum's concerns about the reasonableness of the fees presented in the commission's petition. First of all, I want to make clear that this amount is comparable to that spent in similar appeals. The Department of Law billed a total of 140.5 hours, petitioners conceding that it should be lowered to 139. And I looked at 3 other appeals for the Division of Real Estate cases in recent years that went up to the Court of Appeals, all of which also did not have oral argument, which obviously requires more preparation time and billing. And those matters billed 171 hours, 309 hours, and 220 hours respectively. So when compared to the 139 hours billed in this case, these hours are eminently reasonable just on the surface. The quorum's response tries to compare costs for district court level trials to the attorney's fees request in this case. But the amount of time the quorum's attorney thinks is appropriate to spend preparing for a low-level jury trial is simply not relevant to the amount of time spent by the Department of Law in defending an appeal. Similarly, the reference to the Weinstein case, which was a case where the court awarded $20,000 in attorney's fees for an appeal, is not relevant because a big part of that case was the fact that the prevailing party received only nominal damages of $13. And in private civil litigation, the amount of money recovered in the lawsuit is relevant to what reasonable attorney's fees are. That's simply not the case in a licensing matter because the monetary penalties are generally pretty low. There's an upper limit set by statute. And the more important measure of success is whether the license, or in this case, licenses, are revoked and the public is protected. In this case, the amount billed includes motion to dismiss briefing, which was the commission's attempt to both mitigate the cost of briefing a full appeal and alert the quorums that their appeal was frivolous because they never filed exceptions. And at that point, to avoid having to pay the commission's attorney's fees for a frivolous appeal, the quorums could have chosen to withdraw their appeal, but they chose not to, and the commission incurred substantially more attorney's fees as a result. The amount billed also includes the additional cost to the commission of dealing with the quorum's late filing in response to the motion to dismiss and their motion to set aside the dismissal, both of which were also due to the quorum's attorney's negligence. So this case required additional work because of the quorum's failure to comply with deadlines. And in awarding attorney's fees, the court found that the quorums both had no legal basis for filing an appeal because the law requiring exceptions to be filed first was very clear. And the court also found the quorum's attorney committed multiple instances of misconduct which warranted attorney's fees. That resulted in the Court of Appeals imposing joint and several liability for the attorney's fees on the quorums and their attorney, which means that they both are responsible for the full amount. Finally, I want to briefly address the quorum's claims of duplicate billing. The Department of Law has an appellate process that we have to follow for every Court of Appeals case. We have multiple levels of review that ensures high quality work product. Sometimes billing on the same topic reflects fractured time spent on the same things. So that just means it took more than one billing occurrence to get through that task. The quorum specifically critiques 6.5 hours billed by Ms. Fisher, Jana Fisher, who they speculate is a paralegal. She's actually our Assistant Solicitor General. And her role is to review all appeals filed by the Business and Licensing section to ensure consistency. She also coordinates with the Solicitor General of the entire office. Solicitor AG review is important in this case because the Department of Law rarely asks for attorney's fees. They only do so in egregious cases where it's clear that the appeal was frivolous. And so Ms. Fisher billed a total of 6.5 hours for her entire review of this appeal. That's eminently reasonable. Finally, the claim that multiple attorneys were performing the same work, that reflects an unfamiliarity with the fact that multiple attorney review of the same appeal is standard practice at the Attorney General's office. We take appeals seriously. We have multiple levels of review to ensure good work product. And again, the amount billed here was less than in other appeals for the Division of Real Estate that did not require oral argument. Undoubtedly, if the Department of Law were actually billing at market rates, you could find an attorney at market rate who could have done it cheaper, but that's not the standard for reasonableness of attorney's fees. When you're talking about legal representation, you get what you pay for, including multiple levels of legal review, multiple sets of eyes on documents before they get filed with the Court of Appeals. And how the Department of Law handles appeals isn't the issue before the commission. It's sufficient that the hours spent here were less than that usually spent defending an appeal, and that time was well spent. The commission prevailed. It succeeded in revoking the licenses of 2 licensees who were submitting fraudulent proof of funds letters and offers and causing public harm. It's consistent with other similar appeals, and the commission would, or the petitioner would ask that the commission award the fees requested, submits that those fees are reasonable in light of other appeals, and requests that the commission set a due date for payment in its order. That way the order can be used to seek a judgment in district court if necessary.
Great, thank you. Does any commission members have have any questions for the petitioner?
Just really quickly, can you remind me of the number of hours that you spent, that the commissions or the attorney spent on this? Just for.
Yes, Commissioner, the total hours was 139. That actually includes paralegal time.
Great. Thank you so much.
No problem.
Any other questions?
Just to clarify, you mentioned the total, and the total had already, the 39,240, you had already taken out the hour and a half that was incorrect. Is that right, Gina?
That's correct.
Okay.
Any other questions? Right, seeing none, for the respondent, please proceed with your argument.
And Ms. Ressler, you should have access to the microphone and video.
Can you see me and hear me?
Yes, we can.
There's some feedback.
Are you joined with 2 separate devices?
Can you hear me now?
Yes.
Yes,
Yeah.
a lot better.
Okay, thank you. So I'm going to rely on the brief, or the objection rather, to the affidavit for reasonableness regarding the reasonableness of the fees and costs primarily. As to the specific objections, and in particular, the duplicate billing that council mentioned is not just multiple review of their work product, but rather multiple review of pleadings that are being filed by my office. So multiple attorneys reviewing the same pleading, which that may be a practice, but this is about the reasonableness of fees. And I think a district court, council referred to it as a low-level trial in district court. There's actually significant more work involved in a low-level jury trial, a lot more hours devoted to a jury trial in district court than there would be in an appeal. Council mentioned 2 other appeals she compared it to. I would submit to the commission that if we compared the fees to other trials or other appeals that may not involve the commission, that the almost $40,000 is extraordinary without a legal argument. This was a very basic issue. I'm not contesting the groundless or the frivolous nature of it. As council mentioned, that's been decided. The sole issue here is the number of hours devoted to this and whether or not that is reasonable. And reasonable not just for the commission, reasonableness for everybody. So the commission may choose to do things, or not the commission, the Department of Law may choose to do things a certain way, but is that reasonable in the context of appellate law and district court law, legal litigation in general? This, again, was not a complex legal, as council mentioned it, the sole issue was did the petitioner or did the respondents file exceptions? They didn't. And the court found because they didn't, the court didn't have jurisdiction, not a complex legal issue. So to have multiple attorneys review the same documents over and over to the point where it exceeds the amount of a 3-year, 4 to 5 day jury trial is, I think, patently unreasonable. This is not meant to be punitive. It is meant to be, certainly it's a sanction, but it has to be reasonable. It is not just a blanket fee for whatever it is a department and all the attorneys routinely charge and what they routinely do. It has to be reasonable to all litigants involved. And what this appears to be is punitive with respect to the outcome. And certainly, the outcome was what it was. And keep in mind, this $40,000 only relates to the appeal. So, which again, no oral argument, that 139 hours, when you just take a step back and think about what that looks like, that is likely 1/3 of the salary, or maybe approaching 1/2 of the salary of the attorneys working on this case for the year. That is unreasonable. It's almost an entire salary for a starting district attorney for the year in El Paso County. It's certainly more than half for the entire year. This is one appeal, and the respondents and I should absolutely pay the attorney fees, the reasonable attorney fees in this case. I think that once again, if I look through, I don't think I need to reread some of these paragraphs in the objection. I would just incorporate that by reference. But studying the notice of appeal, multiple attorneys studying the notice of appeal, multiple attorneys revising the motion to dismiss. These are short pleadings. This was not a complicated motion to dismiss. This was not a complicated motion for extension. In district court, when we have a motion for an extension, it's 2 pages. The response is usually 2 pages. It doesn't take multiple hours to object and file a 2-3 page objection. And it certainly doesn't take more than one attorney. And I understand, once again, they have the opportunity to bill a certain way, but that doesn't mean it's reasonable for everybody else. I assure you that if I charged, if any firm in town, and I've seen hundreds of affidavits of attorney fees over 17 years, I've never seen this kind of duplicate work before in civil litigation practices, because clients simply wouldn't pay for it. They wouldn't pay to have 3 attorneys looking at the same thing and a paralegal looking at the same thing. Certainly review and revising it, but there's no difference. You cannot tell in the billing records what the difference is, what one attorney is doing versus another attorney. It's simply revising. And so I don't believe the entries are specific enough, which is also required by the law. In the case that I cited in the objection, it has to be very specific. You can't tell, other than revising or reviewing or brainstorming, you can't tell specifically, and clients require that. Private parties paying these bills require, they want to know exactly what their attorneys are doing for $300 an hour, $250 an hour. So I don't think a private party would pay anything close to this. I think a district court judge would strike this. And counsel referred to other cases. I've had probably 10 appeals in district court level, not involving real estate commission, where the maximum fees after oral argument, complicated cases, were roughly $15,000 years ago. So the idea that this is this rather simple, straightforward appeal is $40,000, approaching $40,000, I would ask is unreasonable. And again, I'm not objecting to paying reasonable. I think it's appropriate under the circumstances. I agree. And so I can't fathom how counsel, on the answer brief alone, 75 hours. That simply wouldn't happen in private practice. That's all I have.
Thank you. Does any of the commission members have questions?
I do, Madam Chair. Ms. Ressler, you say you have no objection to paying attorney's fees that are reasonable, but I haven't heard you state an amount that you feel is reasonable for you or your clients. Can you give us a number that you feel is reasonable and how you came up with that number?
Yes. So I would, and it's my responsibility. I'm going to pay 100% of what is ordered because it was my responsibility to tell the client, look, to reiterate several times, it's not worth it. It was my responsibility to say, look, I can't, that was I will be paying whatever is owed. So just so everybody knows, they don't have to, I heard the joint and several comment earlier, but I will pay whatever it is, whatever the commission orders. I have looked at previous appeals, pleading complicated motions for summary judgment. So I looked at where, complex legal issues, and I think 10,000 to 12,000 is appropriate given the number of hours that would be reasonable in providing an answer brief. So remember, there's just the answer brief filed by, there aren't two, there's not the opening brief is by the appellant, and then the appellee does the answer brief. So that with one brief, I think 10 to 12,500 would be reasonable under the circumstances. And I did that from comparing complex motions for summary judgment. I've had 3 appeals, and I did included oral arguments. So I've done 3 appeals before the appeals court, and looking at the amount of time that I devoted to those, and even including when I was the appellant and drafting 2 briefs.
Thank you.
Are there any other questions for the respondent? Seeing none, thank you, parties in council. This concludes oral arguments. At this time, we could deliberate in here in open meeting, or if anybody has any further questions for our legal counsel, we can do a motion for executive session. Are we good to deliberate in open session, or would you like an executive session?
I'm good to deliberate.
Yeah.
Okay.
I'm good to deliberate too.
All right. Commissioners, the floor is yours. Who wants to kick it off in discussion?
Okay. Yeah, I mean, I guess I'd kind of like to hear from the other commissioners about what we think is sort of reasonable at this point. I mean, are we thinking, the respondent said 10 to 12, and I think the state's looking for 39,240. I mean, are we kind of thinking that maybe we should try to meet somewhere in the middle? Because I sort of did scratch math on a piece of paper, and that comes out to about 25,645.
So I will say, knowing, I mean, it kind of feels like it just outlines what happened in this case, where, multiple attorneys reviewing pleadings or items, I believe, shows that there was a lot of thoroughness, and responded having missed extensions, deadlines, forcing an appeal, even though they were, advised not to. I feel strongly in the petitioner that I would move to grant the petitioner's fees as requested. I would not want to meet in the middle or reduce that.
I agree with Joe.
I also agree.
So, I mean, if there's no other discussion, or if there's other discussion, please let me know.
I have a bit different of a take. In my experience, attorneys can often overestimate how long it takes to do things, or will duplicate efforts when it may not totally be necessary. I'm not saying that happens in every case, and I wasn't in the room in this instance, so I don't know that for sure, but in my experience, that can happen. That being said, when you do split the difference between the two, 25,000 and change, to me, in the spirit of bringing this to a close, that does pass the sniff test. I think that 25,000 and change passes the sniff test in the spirit of bringing this to an end.
Well, and actually, if we're splitting in half, it's 19,260.
And the way I did it was I added the top two and then just sort of split in half, did the average.
So the midpoint between 39,240 and 12,500, that's the 25,000 and change.
Gotcha.
Yeah.
I do appreciate respondent taking ownership for her clients, that this was her choice. I feel like there are some parts in the case where maybe the review work was a bit doubled on that. And so I think that I would be aligned with Graham in thinking more around the 25,000 and change is where I'm thinking.
I thought Graham was just telling us what the midpoint was. I thought he was agreeing with the whole amount.
Well, I'd
No.
like to kind of clarify what I
Yeah.
Yeah, so I was throwing it out there that I did the scratch math.
Okay.
I wasn't agreeing with the 39,240. I was sort of agreeing with Commissioner Chang on saying that, like, I think that they did a very thorough job, and kind of hoping to kind of kick off more of a discussion as opposed to saying, hard and fast, I think we should be going with 39,240. So
I just think reducing is discounting the work they did, and it's work I'm sure they did not want to do. They wanted to put, those resources elsewhere, but it was the respondents that continued this. So because of that, I would say that's why I wouldn't be for reducing the fee. Even as to put it to bed, so to speak. I just think that's the wrong reasoning.
Any other discussion? If we do not have any other discussion, I will request a motion.
So I move to award the petitioner fees as requested.
Commissioner Chang, just to clarify, and that would be to include the reduced amount that they stated today.
Correct, the 139 hours total.
Second.
We have a first and a second. Any further discussion? Hearing none, all those in favor?
Aye.
Aye.
Aye. Any opposed?
Opposed.
All right, motion passes as presented.
And Madam Chair, if the commission so inclined, can you delegate authority to conflicts counsel to draft that and to the division to sign off.
Yes. We need to do that in a motion, correct?
Yes, and Chair, to add to that, would the commission add a date that the fees need to be paid by?
Okay, and that, if we need to add a date, can we sort of get a, sort of a, what is reasonable for repayment, or what is kind of standard as far as a time frame? Is it a year? Is it 2 years or 6 months? Is it immediate?
Deputy Director Turner, is there a standard time frame for like when fines are due and payable? Is it?
Well, usually it's dependent on the case. I've never seen attorney fees awarded since I've been here. So I don't know if I have anything to add.
Yeah, because I was wondering if this falls into a different category than what our, citing like a statutory violation fine would be. So.
Yeah, I mean, I think it's really up to you all. You could certainly set it, 30 days, 60 days out. And then also, I don't know if the manner of payment matters here. If it should be paid online or by check.
So typically we do have a system where they can pay it online. I believe they'd have to set up an account. I believe that's possible. And typically fines are, anywhere from 30 days up to a year.
Okay. And there's a chance that they may appeal this, right? Just so I'm going back. Sorry, I have questions now. If we have to set a timeline, because 39,240 is, I think probably considerable for someone to pay in 6 months.
I would say a year.
Yeah.
I would give it a date of a year out. Because they can make payments, I'm sure, if they open an account. Or usually we're not in the weeds of this kind of stuff.
Right. Yeah. I mean, I'm wondering, I guess, is the fine, the attorney's fees, I'm assuming that goes back to the Department of Law, correct? So I'm not us. So I'm assuming they'd probably maybe set up a payment plan or something. I don't know. Okay.
These are fees awarded to the commission.
Okay.
All right. So we need a date, and then we need a motion to I apologize, Eric. What was the motion we needed?
Delegate.
Yeah, delegation for conflicts counsel to draft the order and the division to execute it, if you're so inclined.
All right. Is someone comfortable making that motion with the date of a year out?
Sure, I can go ahead and do it. Madam Chair, I move that we delegate to conflicts counsel and the division to sign or to execute on the agreement and to add a date of repayment of 12 months.
We have a second?
Second.
And second, any further discussion? All those in favor?
Aye.
Aye.
Motion passes as presented. I appreciate everybody's hard work on today's hearing and bearing with us. Hearings is not something that we do very often. So thank you, everybody. All right, I believe we are ready to move on to complaint and investigation and audits.
Thank you, commissioners.
Thank you.
Thank you.
Good morning.
Good morning.
The first commission matter A is complaint number 2023-879. The complainant, who was the homeowner of a property managed by the respondent, alleged that the respondent did not provide on-site inspections of the property, which resulted in vandalism. This allegation was not substantiated. The investigation noted that the respondent did not obtain an executed brokerage duties addendum to the property management agreement, lease agreement, brokerage duties, brokerage disclosures to tenant form, or perform on-site property inspections during his 2 years of managing the property. During the review of the respondent's documentation, the property management agreement did not list the required commission language or drafting attorney information. It was observed that there were possible license law violations regarding the brokerage escrow accounting practices and fiduciary cash balances for his three-way security deposit reconciliations for the months of February, March, and April of 2023. However, it appears that the respondent has gained compliance for his May 2023 security deposit trust account reconciliations. Possible violations include 1210-217-1M, 1210-217-1Q, Rule 7.1, Rule 5.8, and Rule 5.14. Recommendations for discipline is diversion, a fine of $2,500, coursework in trust accounts, and coursework in property management. And Investigator Geske can answer any questions that you may have.
Thank you. Commissioners, any questions?
I don't have a question about that, but is there a way to get those up on the screen? Don't we normally have them on the screen?
No.
No?
Mm-mm.
Okay, I'll open it up differently.
Were there any questions? Hearing none, may I get a motion?
Sure. Madam Chair, in investigative matter A, I move that we accept staff's recommendations as presented of diversion, a fine of $2,500, coursework in trust accounts, and coursework in property management.
Second?
Second?
Thank you. Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes as presented.
Commission matter B is complaint number 2022-2033. The complainant, who was a tenant in the property managed by the respondent, alleged that the respondent miscalculated the amounts due for reimbursement of her security deposit and did not provide them in a timely manner from her departure of the property. The complainant stated that she did not receive proper itemization notification of retained expenses from the respondent in a timely manner upon moving out of the property. However, there was insufficient evidence to prove that violation. The investigation noted additional potential violations that the respondent was using a non-compliant property management form and performing trust accounting procedures, which do not appear to be in compliance with license law. Possible violations include 1210-217-1M, 1210-217-1Q, Rule 5.14, and Rule 7.1. Disciplinary recommendations are diversion, a fine of $2,500, coursework in trust accounts, coursework in property management, and a follow-up audit within 3 months. And Investigator Geske can answer any questions.
Thank you. Any questions? Hearing none, may I get a motion?
Motion to accept staff recommendations.
Thank you. Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Commission matter C are 7 complaint numbers. 1 second here. Complaint numbers 2023-13, 109, 177, 533, 962, 2022, 1022, and 2022, 1023. This report consists of 7 separate complaints. The complainants who employed the respondent to manage their properties allege that the respondent did not respond to their communications, did not provide rental proceeds, and did not return security deposits as stated in their agreements. The investigation noted that the respondent was non-responsive to the investigator regarding all but the first complaint. Therefore, subpoenas were issued to gain financial overview of the respondent's business practices. During the review of banking information, multiple irregularities were discovered. Additionally, it was observed that the respondent's property management agreements did not appear to be in compliance with the license law, and brokerage disclosures were not provided. Possible violations include 1210-217-1W, 1210-217-1Q, 1210-217-1H, 1210-217-1I, 1210-217-1M, Rule 5.9, Rule 5.15, Rule 7.1, Rule 5.21, Rule 6.5, and Rule 6.25. Disciplinary recommendations are public censure, a final agency order, revocation, and a fine of $25,000. And again, Investigator Guskey can answer any questions.
Do we have any questions? All right, seeing done, may I get a motion?
Motion to accept staff recommendations.
Thank you. Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes as presented.
Commission matter D is complaint number 2022-1938. The complainant and his wife, who were going through a divorce, were represented by the respondent in a listing of their property. The complainant alleges that the respondent and his wife rejected all offers made. This allegation could not be substantiated. The complainant also alleged that by allowing the property to go into foreclosure, his wife's family was able to purchase the property via a short sale. This allegation could not be substantiated. The investigation did find inconsistencies with the e-signatures of the complainant as alleged, as well as the e-signature of his wife and the e-signature of a client in a separate transaction, which was reviewed as part of the investigation. Possible violations include 1210-217-1Q. Disciplinary recommendations are public censure, a final agency order, a fine of $1,000, and coursework in ethics. And Investigator Gabarty can answer any questions that you might have.
Any questions on this case? Hearing none, may I get a motion?
Motion to accept staff recommendations.
Thank you. Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Okay, commission matter E is complaint number 2022-1986. The respondent is the employing broker for a brokerage, which offers a promotional fee to a homeowner in exchange for entering into a 40-year agreement, which purports to be a covenant running with the land and binding on future owners, creates a lien against the residential property, and allows the brokerage to assign their interest without the agreement of the current homeowner. The agreement has a penalty if at any time in the 40-year term, the homeowner transfers title without using the brokerage to sell the property. The penalty is 3% of the home's value as determined by the brokerage. A licensee who was employed by the brokerage stated that she was not supervised by the respondent on matters dealing with the home benefit agreement, but rather was supervised by individuals unlicensed in the state of Colorado. The respondent failed to provide documents as requested with the notification of the complaint. Possible violations are 1210-217-1K, 1210-217-1M, 1210-217-1R, 1210-217-1W, Rule 6.3, Rule 6.22, Rule 6.25.2. And the disciplinary recommendation is a final agency order, public censure, a revocation, fine of $15,000, and a direct referral to the Attorney General's office. And Investigator Pat Hardy is here to answer any questions you may have.
Thank you. Questions or comments? Hearing none, may I get a motion?
Motion to approve staff recommendations.
Thank you. Second,
Second.
any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Matter F is complaint number 2023-133. The complainant was the listing broker for the subject property beginning in June of 2022. The complainant had an active exclusive right to sell listing agreement with the seller, although the property was withdrawn from the MLS at the seller's request. The respondent entered into an exclusive right to sell listing agreement with the seller in December of 2022. The respondent's exclusive right to sell stemmed from an agreement the seller signed in which he received a $1,600 promotional fee in exchange for a 40-year right to list the property, or a $17,974 termination fee. The seller stated that he was not told the terms of the contract. Once the seller reviewed the terms himself, he tried to terminate the respondent's agreement within 3 days, but was told that the 72-hour right to rescind had expired. The seller and the complainant stated that the respondent continued to contact the seller after she was notified of the existing broker representation. Possible violations are 1210-217-1W, 1210-217-1M, 1210-403-4C, and Rule 6.15. The disciplinary recommendation is a final agency order, public censure, revocation, a fine of $7,500. And then it also should be added a direct referral to the Attorney General's office. And Investigator Hardy's here to answer any questions you may have.
Any questions? Hearing none, may I get a motion?
Motion to approve staff recommendations.
A second?
Second.
Any further discussion?
Did we need to add in the direct referral to the staff's recommendations, or?
I can just add that to my
Okay,
recommendation.
all right, I
Yeah.
just wanted to make sure that it was, okay.
Thank you. Yes, the direct referral to the Attorney General's office is added with my recommendation.
Any further discussion? All those in favor?
All right,
Aye.
Aye.
Aye. Any opposed? Motion passes as presented.
Matter G is complaint number 2022-982. The division received a complaint which alleged that the respondent failed to perform his duties as the complainant's listing broker and failed to release the complainant from the listing. There was insufficient evidence to prove a license law violation related to these allegations. The investigation found that during the transaction, the respondent wrote an offer for the complainant at a time he knew them to be under contract on another home. He did not appear to have an exclusive right to buy with the complainant or provide the complainant with a brokerage disclosure to buyer. He stated that he did not ask the complainant if they had an exclusive right to buy with another broker, even though he knew them to be working with the other broker on a home purchase. Review of these additional files appeared to lack proper written disclosures of brokerage relationships with the respondent's buyers. Possible violations are 1210-407-2B, 1210-407-3CF, 1210-217-1M, 1210-217-1Q, and Rule 6.5. The disciplinary recommendation is coursework in brokerage relationships, coursework in ethics, a diversion, and a fine of $1,500. And Investigator Hardy's here to answer any questions you may have.
Thank you. Questions or comments?
I think the fine is too low on this one. There are so many issues with the files that were reviewed, not just the case, but also the additional files and the lack of disclosures. I think the fine should be increased.
Okay, Renee, what were you thinking?
At least 2,500, if not more.
Yeah, I was kind of thinking 2,500 here would probably be fair because there is a decent amount here.
Any other discussion? May I have a motion?
I motion to approve staff recommendation with the increase of the fine to $2,500.
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Matter H is complaint number 2022-1242. Complainant was the buyer of a home. The respondent was the listing broker. The complainant alleged that the respondent provided falsified receipts for work that had agreed to be done per the inspection resolution. The complainant alleged that the falsified receipts were used to encourage her to close on the purchase of the home when the terms of the contract had not been met. The complainant stated that even after closing, the respondent continued to make misrepresentations. The respondent stated that she had an invoice to document her statements. However, as of the date of this report, that invoice has not been provided. In an initial conversation with the seller, he stated that he had not signed an amendment to the contract and an inspection resolution. In a follow-up conversation, he stated that he had instructed the respondent to make the transaction as smooth as possible. As of the date of this report, the respondent has not provided evidence of the documents being sent to the seller for signature. Possible violations are 1210-217-1M, 1210-217-1C, 1210-217-1Q, 1210-404-1B, 1210-217-1W, and Rule 5.21. The disciplinary recommendation is a final agency order, public censure, revocation, and a fine of $12,500. Investigator Hardy is here to answer any questions.
Thank you. Any questions or comments? Hearing none, may I get a motion?
Motion to approve staff recommendations.
Thank you. Do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented.
Matter I is complaint number 2022-1185. The transaction failed because the buyer could not obtain a loan before closing. Complainant alleged that respondent, who was acting as his real estate broker and mortgage loan originator, failed to timely communicate with him regarding the transaction and the loan. Complainant further alleged that respondent electronically signed his name to the earnest money release, releasing the money to the sellers without his permission. The investigation also addressed the potential violations that respondent failed to timely establish his brokerage relationship with the complainant, failed to maintain a complete transaction file, and failed to provide complainant with copies of the transaction documents. The respondent also included a $25,000 appraisal gap provision in the purchase contract that he never explained to the complainant, according to the complainant, and that the complainant did not understand. Possible violations are 1210-217-1M, 1210-217-1K, 1210-217-1Q, 1210-405-1B, 1210-408-2B, Rule 6.5 and Rule 6.20. Disciplinary recommendation is a final agency order, public censure, revocation, and a fine of $15,000. And investigator Denise Wright is here to answer any questions you may have.
Thank you.
Does he still have an active MLO license?
That license expired, here, let me tell you, Commissioner. December 31st, 2022.
Okay, so at this time, he does not have an active license with the real estate division or as a mortgage loan officer, correct?
He has an inactive license with the Division of Real Estate Commission. And then he has an expired MLO license. Yes.
Okay.
Any further discussion or questions? Hearing none, may I get a motion?
Motion to accept staff recommendations.
Thank you. Do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes as presented.
Matter J is complaint number 2023-1052. On April 24th, 2023, the respondent was convicted of a Class 5 felony, menacing the real or simulated weapon. The conviction was not reported to the Colorado Real Estate Commission. Possible violations are 1210-217-1N, 1210-217-1P, 1210-217-1M, and Rule 6.23. Disciplinary recommendation is a diversion and a fine of $500. And Investigator Levy is out of the office today, but I can answer any questions you may have.
Great. Any questions? May I get a motion?
Motion to accept staff recommendations.
Do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes as presented.
Commission matter K is complaint number 2022-1745. The complainant, who resides within the subdivision of the properties listed by the respondent, alleges that the respondent's MLS listings falsely advertised the property as being subdividable and not restricted to covenants, when in fact the subdivision had been controlled by covenants, conditions, easements, and restrictions since November of 1995. The respondent indicated that he relied on information provided by the sellers in the first and second transaction. The respondent did not disclose in his subsequent MLS listing that he had conflicting information regarding the validity of the covenants. Possible violations include 1210-217-1M, 1210-404-3A, Rule 610. And our recommendation is a dismissal with a letter of concern for insufficient evidence. We did not see anything that rose to the level of formal discipline, but we wanted to bring it to your attention and have you make the final decision.
So I was confused if there were multiple listings, and after you learn that there are covenants, it should be disclosed in the subsequent listings, and they weren't. So I don't understand why it's a letter of concern when it looks like it's fairly clear that there was an issue that was not resolved later down the road.
He was relying on the information that the sellers provided to him in the first 2 listings. And then the 3rd listing, he did not update that he had conflicting information.
Okay, but he did state that when you get the title commitment, it's on the title commitment. After you look at the first title commitment and see that there are covenants in that neighborhood, you would know that's the case going forward. Yeah.
Commissioner, with the first sale, though, the seller had told him that the covenants weren't valid. And so he doesn't have an independent duty to investigate the validity of those covenants. He can rely on what the seller tells him. And we also wouldn't expect a broker to opine on title commitments and the legitimacy of any exceptions. So I think that was the concern that we had with the first 2 transactions, is he's got this information from the sellers that these aren't valid covenants. And it's on the buyer to do an independent investigation on whether those are valid or not and seek legal assistance. Then you've got the 3rd case where the best thing he could have done is said that there was conflicting information about whether these covenants are valid or not. You need to go get some legal counsel.
So the information that's put in the MLS doesn't have to be correct?
Well, he was relying on what his sellers told him.
I could understand that for the first one, but then after you find out what it actually is, the information should be listed correctly, because people are relying on what's in the MLS to purchase the property.
So it was staff's opinion that with the 3rd listing, he should have flagged that there was some inconsistencies about the covenants, that they needed to do their own due diligence. You may feel differently, though, and that's why we brought this case to you.
Was there any other questions or concerns from the other commissioners?
Was there anything in the investigation that showed that once he became aware of the incorrect information that had been provided to him by the seller, is there anything that shows he then went back to the seller to say, hey, I don't know if this is correct? And then the seller maybe insisted it was. I guess what I'm trying to get to the bottom of is, once he realized it was incorrect information and it stayed in the MLS, was it at the seller's insistence, or why did it stay that way? Do we know?
Commissioners, the respondent didn't state anything of the like.
Joe, you have that face.
I always have that thing. No, I just, yeah, I agree with Renee. There were some comments about the title that I thought was odd, but if it was just one transaction, I could understand, but then 2 and then 3, especially not disclosing or saying anything that there might be conflicting reports, that is what I'm thinking about. That kind of irks me, I guess.
The comment was that the MLS was merely for marketing purposes, which indicated it didn't have to be accurate, which is a problem.
Well, and the thing is, I believe most of the MLSs, the listings does say in fine print at the bottom, it's not guaranteed information, it's just for marketing purposes. So it's that weird boundary of like, how far do you go as a listing broker to find out information if your seller's telling you one thing, and then
But that's the scary part, right? Is because, you know, we tell the brokers to stay within their scope. Right? So their scope is not title insurance. Their scope is not working for an HOA. Nor do we want them to have that liability, right? For misinformation. So we have to be very careful on what we're saying we're expecting. Yes, I do agree that, you know, on the third case, maybe should something have been said, or, but again, this is a learning moment. You know, a letter of concern is something that's still, you know, this broker is going to understand that going forward, right? But ultimately, we want them to stay in their lane. And we can't be telling them something, say like in the correct update, stay in your lane, don't give advice, don't, you know, that kind of thing. But then we're disciplining because they're not doing those things. So we have to be very careful.
Yeah.
Do we have any further discussion? If not, may I get a motion?
Motion to accept staff recommendations.
Thank you. Do we have a second?
I second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes as presented. We only have 3 more cases, so I say we just kind of just plow through. Is that okay with everybody?
Sure.
All right, we are on to licensing matters.
Licensing matter A is complaint number 2023-948. This is a preliminary advisory opinion. On November 29th, 2012, the applicant was convicted of marijuana cultivation, 7 to 29 plants. A deferred sentence was granted in 2012, which was subsequently revoked, and a guilty plea was entered in 2016. The applicant has completed probation and has paid the fine in full. Case is closed. There is no disciplinary recommendation, and Investigator Quinton is here to answer any questions you may have.
Thank you. Any discussion on this case? Hearing none, may I get a motion?
Motion to accept staff recommendations.
Now, motion for a positive opinion on the preliminary advisory. Or that's not how you say it. Motion for a positive opinion.
So Josh, on the license.
Yeah, I don't have it in front of me. I apologize.
No, that's okay. All right, so we have a motion for a positive opinion. Do we have a second?
Second.
Thank you. Any further discussion? Motion passes for positive opinion.
Licensing matter B is an application. The complaint number is 2023-1344. The applicant was the respondent in a complaint which alleged license law violations in conjunction with transactions involving an 80-year-old man. Those transactions resulted in multiple foreclosures. In 2013, the applicant signed a stipulation which included voluntary surrender of her employing broker level associate real estate license. Each surrender is treated as a license, or I'm sorry, such surrender is treated as a license revocation. The stipulation also included a fine of $49,500 and public censure. In the stipulation, the applicant admitted to violations of demonstrating worthiness or incompetency to act as a real estate broker, disregarding or violating a commission rule, and also commission rule E-5, failing to provide complete and accurate closing statements. The applicant applied for a preliminary advisory opinion, which was considered at the February 2023 meeting of the Colorado Real Estate Commission. This received a negative opinion. Applicant applied for an associate level real estate license on July 3rd, 2023, and provided an updated personal statement, copies of her license in another jurisdiction, and a 5-year employment history. The recommendation is denial. And Investigator Hardy's here to answer any questions you may have.
Did we ask for more letters in February? Do we remember?
Not to my recollection, no.
There was one that we asked in the previous meeting, I think in June, that we asked for more letters of recommendation.
A different applicant, you're saying? Yes. Yep.
So you're actually recommending a negative on this?
Yes, the division is recommending a negative or a denial.
I have a factual question. I'm at a sensory disadvantage today. I'm in a hotel room and all I can see is just my little laptop screen. So I'm not able to have these files in front of me. Is this the one where the fine that had been levied back in 2013 wasn't paid until like late 2022? Is this that one or am I mixing it up?
It was paid in 15.
Okay, all right. Then I'm mixing this up with another case. Sorry.
I can look in the report, but my recollection is that it was not paid until she applied for her preliminary advisory opinion, which was in 2023.
Okay.
That
concerns me.
I remember.
Am I correct on that?
So, yeah, so good morning, commissioners. She paid, there was like a $2,000 portion of the total $49,000 portion. She paid $2,000 right after that initial decision. Yep. And then the balance was stayed until and unless she applied for a license. And so then it was in 2023 that she paid that larger balance.
Okay.
That's a good memory, though, from just going off of memory, Josh.
Well, I remember my comment on this. I believe at the time the personal statement was a lot more sugar-coated, didn't really address what had happened and talked more about their successes after. And I appreciate that this applicant did come back and write a more, I guess, thorough and less sugar-coated statement, took responsibility. However, when I go back and review what had happened, the extent of what had happened, how the applicant profited off this elderly man, I still cannot, I would not feel comfortable issuing them a license at this time. So that's where I stand. I would be motioning for a denial.
Do we have any other discussion?
I just want to echo Commissioner Chang. Go ahead, Marcia.
So whatever you decide, if you decide to go for a denial, I do need grounds for your denial, just because we have to keep track of that.
And it would be based off of the prior filing.
You've got a statute on your books that says that the applicant doesn't possess truthfulness, honesty, and good moral character. So I'm guessing that may be what you were thinking of.
I would go off of that, yeah.
Graham, you had a comment.
No, I was just going to say I wanted to echo Commissioner Chang's sentiments on this, especially regarding the profiting off of the. I would not feel comfortable issuing a positive opinion.
Okay. May I get a motion?
Motion to deny.
And that's going to be on the grounds of what Marcia had said, the unworthy income. Okay.
Correct.
And do we have a second?
Second.
Thank you. I believe I heard Graham.
Mm.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes for a denial. And last on our agenda today is ESP.
Good morning.
morning,
The
Penny.
only matter I have for you is, hang on a second, computer issues. Is case number 2022-1239. This individual signed a stipulation back in October of 2022 after failing to pass a CE audit. They agreed to pay a fine and to complete some coursework, and they have done none of those. In the last communication with the individual, they've just sort of made it clear that they have no interest in paying the fine or taking the coursework. So I'm just bringing it to you, as we typically do, to proceed with a violation of 1210-217-1M, violating the order, recommending the fine of $2,500, a final agency order, and public censure.
All right, and they're inactive just due to their own lack of renewing.
They're inactive. Let me confirm that I believe it was a action that they took as opposed to complying, but they still have the ability to activate at any moment. But let me just confirm that that's their current status. Yes, they are inactive. They don't actually expire until the end of next year, so they do have the ability to activate at any moment.
Okay.
So Penny, can you say again what we've got the FAO public censure. What else?
So final agency order, public censure, a fine of $2,500.
Right.
And of course, in that includes the language that they have to comply with the previous order as well. So this fine is in addition to, the concern is that we haven't got them to comply with the first one. I don't know that we'll get them to comply with the second one. Sometimes in these cases, we negotiate a relinquishment, and if they really truly don't want the license, in which case we may stay a portion of the fine. But this is the standard recommendation under these circumstances.
Any further questions for Penny? Hearing none, may I get a motion?
Now, I move to accept staff recommendation. Do we need to list it out, or just what Penny's normal?
No, I think staff.
Michelle? Okay, all right.
Recommendation should be fine.
Okay.
We have a second.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Motion passes for fine up to no more than $2,500, final agency order, and public censure.
Thank you.
Thank you, everybody. And we didn't get to say at the beginning of the meeting, but welcome to our newest commissioner, Josh. Thank you for joining us, even in a hotel without files. Thank you so much for being a part of this group, and hopefully it wasn't too painful today. We don't normally have hearings, but I see Angela popped on. So Angela, did you have something to say?
I just wanted to say thank you all and welcome to Josh.
Well, thank you, everybody. Have a great rest of your summer, because we don't meet again until October. So enjoy the rest of your summer. Have an amazing day, and thank you for all your hard work.
Thank you.
All right.
Thank
Michelle.
you.
Everyone.
Here,
Right.
Thank you, commissioners.
Bye.
Bye.